Can creditors seize funds from a joint bank account? Have you ever wondered what happens to the money in a joint bank account if one of the account holders has debts? This is an important question, especially for families and seniors. Let's break it down. Yes, creditors can seize funds from a joint bank account if one of the account holders owes a debt. If a court issues a garnishment or levy order, the creditor can access the entire balance. This is because joint accounts are usually treated as equally owned by all account holders. So, even if one person deposited all the money, creditors can still claim the whole amount to satisfy the debt of one owner. This situation is particularly relevant in elder law. Many elderly individuals use joint accounts to manage their finances or to give trusted family members access. However, this can lead to unexpected issues if one co-owner has debts. For example, if a senior relies on that account for daily expenses, a creditor could freeze or seize those funds, causing financial stress. Here are some key points to keep in mind. First, the law typically assumes that all funds in a joint account are owned equally. This means creditors can access the full balance to cover one account holder's debts. The non-debtor co-owner must prove that certain funds do not belong to the debtor. Once a garnishment order is issued, the non-debtor has a limited time, often around 30 days, to file a claim with the court. This claim must show evidence that some funds are exempt from garnishment. This could include pay stubs or deposit records proving that the non-debtor contributed those funds. It's also important to note that the burden of proof lies with the non-debtor. They need to actively demonstrate that some or all of the funds should not be seized. Until this proof is accepted, the entire account could be frozen, which can lead to financial hardship. State laws can vary significantly. Some states offer protections that limit creditor access to joint accounts. For instance, in some states, certain types of accounts, like those held by married couples, may have additional protections. To protect non-debtor co-owners, it might be wise to avoid putting funds into joint accounts if there's a risk of creditor claims. In some cases, removing one's name from a joint account or closing it altogether may be necessary to safeguard funds. In the context of guardianship and conservatorship, joint accounts can sometimes serve as an alternative for managing an elder's finances. However, the risk of creditor seizure makes them less secure. It's advisable to consult legal counsel to find better options for asset protection that still allow for effective financial management. In summary, creditors can indeed seize funds from a joint bank account to satisfy a debt owed by one account holder. The non-debtor co-owner has the right and responsibility to prove which funds are exempt. Given the risks, especially in elder law situations, careful thought should be given before using joint accounts as a financial management tool.